Out of Order Gun Rights Podcast, episode 84.
Welcome to the Out of Order Podcast, your window into the firearms community, exploring those shaping the future of our rights and protecting our lifestyle, laws, legal cases, activism, and self-defense in a candid and honest podcast for our brothers and sisters in arms. Here's your host, James Kalita.
Thanks for tuning in to episode 84 of the Out of Order Gun Rights Podcast. Today's sponsor is Gift for Gun Nuts, giftforgunnuts.com, where you can get great gift ideas for the firearms or hunting enthusiast on your holiday shopping list. Today's guest is Andrew Branca. Andrew Branca is the author of The Law of Self-Defense. And now, here's Andrew.
Andrew Branca, welcome to the show.
Very pleased to be here.
So, Andrew, you are the author of The Law of Self-Defense. Would you tell us a little about that book?
Sure. It's a book that sets out, or at least attempts to set out, the legal principles, the elements required for a claim of self-defense to be valid based on the law, actual statutes, court decisions, jury instructions, but translated into plain English so that the law becomes understandable and, more important, actionable for people so they can make legally sound decisions in self-defense.
And I've been reading this book, and I was kind of surprised about how complicated it can be. I think a lot of people have the impression that since in their mind they're the good guys and the other guy's the bad guy, that the court proceedings, if there are any, would be easy. And in your experience, is that often the case?
No, these are very, very treacherous waters indeed, for a number of reasons. It's kind of a curious state of affairs, really, because the law of self-defense itself is relatively straightforward. There's only 5 principles, 5 elements of a claim of self-defense. So it's not an enormously complicated area of the law. What's complicated is the facts that you have to apply those elements to, because the real world gets complicated. And there's no such thing as absolute truth, and by which I mean nobody who's evaluating whether or not your use of force was lawful, whether it aligns with those 5 required elements, none of those people, not the police, not the prosecutor, not the judge, not the jury, they don't know what actually happened, right? They weren't there. So they're interpreting the facts in a particular way, and they may not interpret the facts the way you interpret them at the time. So even if you totally understand self-defense law and believe you made the right decisions based on the facts at the time, that doesn't mean that the people reviewing your conduct after the fact will come to the same conclusion.
And that's a lot of what you cover in the book, is how people can sort of prepare themselves in the same way they would train to use a firearm defensively. They can use what you put in the book to sort of mentally train themselves as to how to avoid complicating their self-defense claim if they need one.
Yes, it's very, very similar. I mean, there's really 2 fights, right? There's the physical fight, and that's always most important. If you don't win the physical fight, everything else becomes rather less pressing. But after the physical fight, you need to expect to have a legal fight as well. And, we prepare ourselves for the physical fight. If we're responsible adults, we prepare to defend ourselves and our families from criminal predators. We need to keep in mind that there's never zero risk, right? You're never perfect at self-defense. I like to tell people the moment you go hands-on in that confrontation, or the moment you make that other person aware you have a gun and you're prepared to use it, you've just incurred 2 risks that you weren't incurring a moment before, a risk of dying in that confrontation and a risk of going to jail for the rest of your life. And there's no way to reduce those risks to zero. It's impossible. So best to avoid a confrontation in the first place. What we do in terms of preparing for the physical fight, of course, is we get a gun or whatever, and we get trained or we learn martial arts, and all those efforts are intended to reduce that risk that can't be zero to as close as zero as possible. What people need to do in preparing for the legal fight is exactly the same thing. You can never reduce the legal risk to zero. There's no way to make it impossible for you to get convicted. Innocent people sometimes go to jail. It happens. But what you can do is prepare yourself so that you're reducing that legal risk to as close as zero as possible.
And you just did something very powerful there, that innocent people sometimes go to jail. And, when we go through public school growing up, that's one of the things they teach us, is that that's supposed to be avoidable and almost never happens, probably never happens, but you're saying it does. And how, understanding that there's things you could do to minimize that risk, how much of a risk is that? How that you'll use a firearm defensively and be wrongfully found guilty?
Nobody knows, right? Because we have a system that determines whether a person is guilty or not guilty, and that's decisive. Well, whatever that system decides is what we believe the outcome to be or should be. So if someone's found guilty in a court of law, we might in our heads want to believe that they're not guilty, but it doesn't matter. They're still going off to jail. The trouble is, our criminal justice system is imperfect. I think it's probably the best in the world, but nevertheless, it involves human beings, and human beings are imperfect, and they're making judgment calls, and not all the judgment calls may, in fact, be correct. It may be aligned with reality, because, again, these people making the judgment calls don't know what the reality is. They weren't there. They're hearing stories about what happened and making judgments about the credibility of the people telling those stories. So they can be misled. It's possible. Now, we have a lot of safeguards built into the system. Things like the fact that in a courtroom, all the arguments being made have to be supported by actual evidence that's introduced in the court, so it can be evaluated by the jury. You can't make claims that don't have any evidence to support them. That's not true out in the real world. Out in the real world, people believe things all the time that don't have any evidence to support them, or even contrary to the evidence, particularly if they're not aware of the evidence. But in the courtroom, we have very rigid guidelines for what's allowed to be said and argued, and everything has to be evidence-based. The problem is evidence itself cannot necessarily be decisive. It can be circumstantial. It can be subject to judgment. It can be subject to credibility. So there's always that risk there. Now, what you can do is, if you know where the legal boundaries are, in the context of self-defense, you've learned what those 5 elements of a self-defense claim is conduct yourself in such a way that you're well away from the edge of the cliff, that you're well inside the law, not on the margins. The further inside the law you are, the less likely it is that judgment calls on evidence are going to go against you, because you're so clearly behind the line. So I always urge people that conduct themselves in self-defense as conservatively as possible, so they're not bordering on that edge of the cliff. That reduces the risk a great deal. Frankly, another way to reduce the risk a great deal is to have a lot of money for a legal defense. There's an enormous difference between a $300,000 legal defense and a $30,000 legal defense. And, if you can't afford a lawyer at all, the court will appoint you a public defender. And I began my legal career in a public defender's office, and I've known a lot of fantastic public defenders. So just because someone's a public defender does not mean they're not a highly skilled attorney. But what it does mean is that they're way overworked. They have a huge caseload. And that's not in your favor if you're one of the defendants they're representing, because they can only give you a fraction of their time. So if people have adequate resources for a legal defense, it makes their legal defense much more powerful.
How helpful are the various I know that I can't officially call them insurance, but insurances and insurance type things that are out there, are they helpful in offsetting that expense, or do they just complicate things? Or
well, some of them are more helpful than others. I should preface any discussion of this in full disclosure. One of the large quote-unquote self-defense insurance companies is USCCA, and for a couple of years I was on their legal advisory board. Another one of the large companies is CCW Safe, and I'm currently partnered with them on some initiatives. And I've worked with various other companies just in the nature of my legal work. So I have a web of relationships with all these companies. So I just want to disclose that up front. These organizations are useful to the extent that they actually cover your legal expenses, importantly, as the legal expenses are actually incurred. If they do that, that's awesome. That gives you a lot more resources than you otherwise would have had. If they don't do that, and believe it or not, some of them don't, then they're not very helpful. So, for example, the there's some of these plans out there that are essentially a reimbursement plan. They might give you a little bit of money up front, but what they largely do is if you're acquitted, they reimburse your legal expenses after the fact. That's not helpful because you need that money to get acquitted. It's like someone saying, well, I'll give you an army if you win the war. You need the army to win the war. So they're going to reimburse you after the fact. I've never been able to recommend any of those plans. There are other plans out there that essentially set up a lawyer network, and they promise these lawyers basically a flat fee for representing any of their members, and typically I think it's in the $30 or $40 or $50 or $1,000 range, which sounds like a lot of money, and it's probably adequate if you're facing something like an aggravated assault charge, which is pretty common for these kinds of cases. But it's not at all adequate if you're facing a killing charge. If you've killed someone and you're being charged with manslaughter or murder, $50,000 is not nearly enough. I mean, you could easily go through $150,000 pre-trial before you even get to the trial. So those kinds of plans I'm not a fan of either because, of course, you don't know what you're going to end up charged with. You don't know what's going to happen. So you can't possibly know if this relatively low cap that they're willing to pay their affiliate attorneys is going to be adequate. Because if you're charged with murder, none of those attorneys are going to take that case for $50,000. And if they're only getting $50,000 from the plan, you're going to have to make up the difference anyway. So I've never been able to recommend those kind of plans either. I will say USCCA and CCW Safe are both plans that I've been more than happy to suggest people look at. I mean, none of these plans are perfect, and they all have various baskets of services that they provide, and I couldn't possibly know what basket would best align with any particular individual. But both of those are credible companies. I've consulted on cases for their members and found them, from at least my legal perspective, working with them to be an excellent experience and with good outcomes for the client.
And I mean, I think you touched on something really important there when we're talking about 50,000 not being enough. I think a lot of people go through life, and I've just picked this up from reading forums and talking to people at ranges, that they won't need that because they're innocent, and they'll only need that if they made a mistake or if they and really that's the amount, and that's the cost you would need to defend yourself because you're innocent. And am I right in thinking that?
Sure. I mean, there's the issue is whether or not you're going to be forced to incur that cost, whatever the cost might be, is someone else's decision. It's a decision of a prosecutor, and there's virtually no check on his decision-making. In many jurisdictions, they do require a grand jury, but the threshold for getting an indictment from a grand jury is so low, it may as well be the prosecutor's sole decision to take you to trial. And he makes that decision, and off to trial you go. That's it. And now you have to go retain an attorney and pay him tens of thousands of dollars. It doesn't matter that you don't like it or that you never thought this would happen to you. You've been fed into the criminal justice machine, and it's like a giant steam engine of gears that are prepared to just grind you up, both emotionally and financially. And you don't make that call. The prosecutor makes that call, and that's entirely outside of your control.
And so for folks thinking about this, what's the timeline? I mean, we have, CSI and Law and Order, and everything gets wrapped up in 45 minutes, but from the time you pull the trigger, if something goes to trial and there's a verdict, how long are you in the legal system?
Well, there's an enormous amount of variance. It can happen pretty quick. A lot of jurisdictions have speedy trial laws, so the moment that you're charged, the clock starts ticking, and the prosecutor has to bring you to trial within 30 days or 60 days, and that's a pretty rapid process. We're all familiar with the trial of George Zimmerman. That was about a 16-month process from when he fired that shot into Trayvon Martin until the end of his trial. So that was a pretty long period, which made, of course, everything very costly. But from my perspective, it's often better for the defendant if the case takes longer because it gives you more time to build a legal defense. Many people will be familiar with another shooting in Florida that involved a retired police officer in a movie theater where someone threw popcorn at him and he shot that person and killed him. He's still awaiting a trial date, and this happened, I believe, 4 years ago at this point. So his defense team is obviously dragging things out as long as possible because they think that's in their favor. So it's very difficult to predict how long it will take. A period of months would be pretty common.
Okay. And
by the way, most of these trials, the trials themselves are much quicker than many people might think, because we're familiar with the high-profile trials that get in the media, and those trials often take weeks, but they take weeks because they're high-profile trials. A typical murder trial, for example, is 2 days, 3 days. That's it. It's over.
Oh wow, that is interesting to know. But that whole process, like for the gentleman who's been waiting 4 years for a trial date, that's 4 years where he has to indicate that he's under indictment. Where if he applies for a job, it comes up as on his criminal record that he's facing charges, and.
Yeah, that doesn't matter for him in particular because he's rather old and retired, and he's on house arrest, so he's basically doing probably what he would be doing retired anyway, which is not much. But sure, for a normal person of working age years, they're under indictment. And by the way, it's extraordinarily stressful because when you're under indictment, of course, you're awaiting trial, and that trial may not go the way you like. And if you're convicted of something like aggravated assault, you could be looking at 10 or 20 or 30, and if it's with a gun and there's firearm sentencing enhancements, maybe 40 years in prison. That's, for most people, that's pretty much the rest of their lives. And people need to understand that it's not that hard to get charged with something like aggravated assault. The moment you make someone else aware that you have a gun and you're prepared to use it, you've put them in imminent fear of deadly force, death, or grave bodily harm. Those are the elements of aggravated assault. You can be charged with aggravated assault, and now you would have to raise the legal defense of self-defense in order to argue that that threat, which would otherwise be criminal, was actually lawfully justified. But you've checked off all the boxes for aggravated assault, and that's a serious felony. In some states, you do that with a gun, which, of course, is what many of us would do, acting in self-defense, right? We see a threat, put our hand on our gun so they're aware that we have a gun, tell them to stay back. That checks all the boxes, and that could be good for decades in prison if you're convicted and your self-defense claim is not accepted.
So in the book you mentioned that you talked about the amount of research you had to do here, and it's an incredible amount. And you mentioned that lots of lawyers don't have experience with legitimate self-defense cases. How do you, obviously not everyone can hire you, depending on what state they're in. How do you find a competent lawyer? And do you find one before you need them, or what's your thoughts there?
So that raises a few points I should touch upon. You're right. I've done a ton of research. I've essentially read all the self-defense law for all 50 states and Washington, D.C. that exists. And this has obviously been many, many years of effort. But I don't want to hold myself out as a super lawyer. I have a very unusual practice. I'm not a go-to-court lawyer anymore. I'm essentially an academic or a consultant to other attorneys. So I don't take clients directly. Nobody would retain me. I'm a member of the bar, but I would not have a client retain me directly. They would retain a separate lead counsel who would be in charge of their case. And if they and their attorney thought it would be a good idea for me to consult on the case, their attorney would call me. And my client is the attorney, not the underlying client. Now, what makes my practice different is that, and also the fact that I don't do anything else. So a traditional criminal defense attorney does all kinds of different cases, DWI cases, domestic abuse cases, theft cases, everything you could possibly think of. And they may have a number of self-defense cases. They typically would. But, when you're a criminal defense attorney, most of your clients are, in fact, criminals. So the self-defense cases they tend to be bad, what I call bad guy cases of self-defense. Everyone who's ever charged with an assault or a battery or an aggravated assault or battery, at some point they want to say it was self-defense because they want to escape legal liability. In most cases, it wasn't self-defense. In most cases, it was just a criminal assault, and they're trying self-defense to get away with it. Those bad guy cases of self-defense are generally pretty easy to beat because they have obvious defects for the prosecutor to attack, and the prosecutor does, and he destroys that claim of self-defense, and the person gets convicted. So a lot of criminal defense attorneys have a lot of experience kind of arguing really weak, defective self-defense cases. Not because they're bad attorneys, because their client gave them bad facts. But they don't tend to have a lot of experience arguing good guy cases of self-defense, because any lawyer gets his business from the immediate community around his office, and there just aren't that many good guy claims of self-defense in any particular small geographic region. So I've spoken to many very active criminal defense attorneys who, over 3 decades, 4 decades of practicing law, they've had maybe 3 or 4 good guy cases of self-defense. So it's hard for a traditional criminal defense attorney to develop much experience arguing good guy cases of self-defense, because he just doesn't see that many. On the other hand, those attorneys have expertise in areas where I no longer claim expertise, because I'm not a go-to-court lawyer anymore. So rules of evidence, rules of criminal procedure. That's why I demand that any case I work on have a competent lead counsel to address all those other areas, so that I can focus strictly on the use of force legal issues in the case. Now, in terms of picking an attorney, frankly, the best thing that people can do for themselves in preparing to be competent at choosing an attorney is to do something like read my book. And because unless they have at least a basic understanding of the legal issues, they don't know what questions to ask that attorney, and they don't know what kind of answers to expect. And if you haven't informed yourself at least a basic level, any criminal defense attorney is going to sound like a genius, because they're saying magic legal words that you don't know the meaning of. If you've at least, say, spent $9 and picked up the Kindle version of my book, you can read it in 3 or 4 hours. You've given yourself a basic understanding of what the discussion should be like. So you know when you're talking to an attorney, basically you're interviewing that attorney before you retain him. You know what that conversation ought to sound like if that attorney himself is competent. Because I hate to say it, but like any other profession, there's good plumbers and not so good plumbers. There's good welders and not so good welders. There's really fantastic attorneys out there, and there's some attorneys who they'll say they can work any case. And you give them your case, and they just kind of sit in their office and crank the handle, and they don't make that extra effort. They're not personally driven in your particular case, because they've already got your money. And keep in mind, if the case goes bad and it results in a conviction, the lawyer doesn't go to jail, right? It's you who goes to jail. So it's important for people to educate themselves to a fundamental level, at least, which isn't that hard to do and doesn't have to be costly, so that they can have that competent discussion. In terms of picking out an attorney ahead of time, I have to be honest, I really don't think that's particularly important, because when are you going to need that attorney? I mean, probably never, right? I mean, most people are not involved in serious self-defense instances. But people often ask me, hey, can you recommend an attorney in my area? And I feel like, well, if I did that today, when would you need that person? In 5 years or 10 years or 15 years? And maybe in 15 years I would be recommending somebody else entirely. So I don't think it's that important. I think if you have an event, the first thing that's going to happen is presumably be prepared. You'll be arrested. You'll be brought in front of a magistrate. You'll be told what you're charged with, and there'll be a bail hearing. And you'll want an attorney present for that bail hearing. But the truth is, any criminal defense attorney can do that, so I don't really care who you get for that. That's a very straightforward process. And you're not stuck with that person for your trial, with that attorney. So have the bail hearing, just pay the attorney for that. When you get out on bail, you can talk to an infinite number of attorneys, interview a whole bunch of them, and pick one that gives you the greatest degree of confidence. Because like we said earlier, you could be living with this guy for months, right? Maybe for more than a year, maybe for years. And the rest of your life hangs on his skill set and effectiveness. So this really needs to be somebody you have confidence in. That's another thing I should mention. Some of these quote-unquote self-defense insurance plans, they have an affiliate network of lawyers, and you can only choose one of those affiliate lawyers. I don't like that at all. I would never want someone else to be choosing my attorney for me. I want to be able to choose my attorney myself.
And you've read the self-defense laws in all 50 states, and are there states that are, if this was a prime concern, that are better to live in than others?
Well, if we look at the black letter law, in terms of the core of self-defense, the core elements, those 5 elements of a claim of self-defense, they're really pretty consistent across all 50 states. And that's because of their history. The doctrines of self-defense were developed at least as long ago as the Roman and Greek eras. They come to us through Old English common law, which of course was one source. So they tend to be pretty consistent across the states. The one major variance would be on the element of avoidance, which refers to whether or not the state imposes a legal duty for you to retreat before you can use force in self-defense, if retreat is safely possible. So there's about 15 states that impose that legal duty to retreat, and about 35, 36 that don't. The number's not specific because there's a couple states that are kind of ambivalent in their laws about whether they're always going to apply that duty or not. But the rest of the other four elements of a self-defense claim are pretty consistent across the states in terms of the black letter of the law. Now, in terms of how the law is applied and in how aggressive prosecutors are in compelling you to go to court and make that case, there's a lot of variance there. There can be a lot of variance there even within a state where you have only one set of laws, depending on what part of the state you're in. You know, if you're in an urban center and you're involved in a gun-related event, well, there's some anti-gun prosecutors who take all those cases to trial because they see them all as gun crimes. And if it's going to be determined to be self-defense, they're going to have a jury do that. There's other places in the country where you can be involved in a gun event and the sheriff comes and looks at it and says, nah, no charges. This looks good to me. It's the same laws and the same facts in both cases, but the determination of whether or not you're going to be compelled to prove it in court varies considerably. And, of course, that really matters, right? Because as we've talked about, the expense of having to go to court is enormous. There are some prosecutors out there who, even if they don't believe they can get a conviction, will take someone to court anyway to use the process of the prosecution as the punishment itself because they know how catastrophically destructive it is to the defendant.
And as you mentioned earlier, there's really no recourse, for the defendant later on. So even if they're acquitted and even if they found evidence that the prosecutor didn't think he'd get a conviction, they can't sue the prosecutor or have him charged or anything. Yeah.
No, it's almost impossible. You see it once every maybe 1 or 2 decades, a prosecutor is successfully sued. But generally speaking, prosecutors have absolute immunity for the decisions they make in their office. And really, they kind of have to, really, because otherwise every defendant who's found guilty or someone who's charged or brought to trial would try to sue the prosecutor, and that would make the system completely unworkable. Prosecutors have a lot of power, and that's really because they need it to do their jobs. If it sounds like I'm suggesting prosecutors should have less power, I'm not making that case. I could have that argument, but I think they really need a lot of power and authority to do their jobs effectively. But what that really means is it's important to have good prosecutors. If you have poorly motivated, badly motivated prosecutors, well, they can create an enormous amount of damage. Now, I mentioned self-defense law is mostly the same across the 50 states. There are kind of the core of self-defense law. There are ancillary parts of the law related to self-defense that can vary quite a bit. One area is whether a state allows for self-defense immunity. So that's generally speaking where you can request a pretrial hearing. You go before the hearing judge, you make your case for self-defense. If you convince the judge that it was self-defense, he can grant you immunity from prosecution and or immunity from civil suits, depending on what jurisdiction you're in. And this is a mechanism that can short-circuit that prosecutor's authority, that can keep him from taking you to trial. So I think these self-defense immunity laws are tremendously important. Every state should have them because what it means is that pretrial hearing's not free. It can still be quite costly, but it might be $10,000 instead of $50 or $100 or $150,000. And it holds out the prospect for someone other than the prosecutor to make the decision that your use of force was self-defense and keep you from having to go to trial and suffer that process as the punishment. So not all states have self-defense immunity. Some that do have it, it's only for criminal. Some it's only for civil. Some have both. But I would consider if anyone listening is an advocate for gun laws or self-defense laws, self-defense immunity would be at the very top of my list. The other place that use of force law varies enormously across the states is defense of property law, including both. They're pretty consistent for defense of just personal property, just items, and that is non-deadly force only and only sometimes. But they vary a lot when it comes to defense of what I call highly defensible property, which would be something like your home, in some states also your place of work, in some states also an occupied vehicle. There's enormous variation across the 50 states on what they allow in terms of the use of force, especially deadly force, in the context of highly defensible property. That's, by the way, one of the reasons I tell people, I urge people, rather, obviously they have to make their own judgment call, to not use force in defense of mere property. Even if the law allows it, if the only thing that's being threatened is property, don't use force. Be prepared to use force only when there's an actual threat to innocent persons. Because we talked about how destructive this process is and how there's never a 0 degree of risk, right? There's a greater than 0 risk of dying in the fight and a greater than 0 risk of going to jail for the rest of your life. And there's no way to reduce that risk to 0. Well, I think it's important to make sure that the stakes are worth those risks. If the worst should happen and you end up getting convicted and sentenced to jail for 20 years, under what circumstances would you be able to look in the mirror on the last day of that 20th year and say, you know what, pressing that trigger was the right thing to do then, and I would do it again now, even knowing the price I was going to end up paying? Because there are circumstances in which that's worth it, right? If you were going to die, or if your wife was going to die, your kids were going to die, but it's not a big list of things that are worth that. And in my opinion, in most cases, property is not worth that.
Right. Yeah, and that was a really powerful chapter. And I was reading that, and I'm going through that list and thinking of all the encounters I've had in my life, and all the scenarios that people talk about. At what point, is it worth shooting? And so you're, in addition to the book, you have courses and other training. Would you like to tell us about those?
Sure. So, in addition to the book, we a lot of the content we distribute these days are via DVD. For many years, I was teaching 40 or 50 live classes a year around the country, sometimes more than that. But to be honest, the travel just became overwhelming. I mean, I looked at my my airline statement, and I had 500,000 frequent flyer miles, and I said, this has got to stop. I mean, I was, and all my classes are on weekends, so I was away every weekend. Couldn't be with my family, couldn't be shooting matches, which I like to do. So we started, instead of teaching the classes live, we've largely shifted to doing them via DVD or streamed online. We offer both. We do about half a dozen live classes each year, but we stream those using a webinar platform, so I don't have to travel to teach those. And these are our core class is what we call our Level 1 class, and that's about a 7-hour course of instruction. When we do it on DVD, we give you those 7 or 8 hours. It's actually longer on the DVD than the live class because we don't have the time constraints on a DVD. And our Level 1 core class on DVD is a 4 DVD set, 7 or 8 hours of instruction. And then, so to make sure you can also get your state-specific laws, we have state-specific supplement DVDs for each state, and that's a single DVD. So in the core class, we explain all the legal principles, and we illustrate them with laws drawn from various states, so people can understand how the principles work generally. And then we fill in the blanks for each individual state by supplementing it with that state-specific DVD that people can purchase separately. We also provide a lot of free content. So we have a Patreon page that's can be found at lawofselfdefense.com/Patreon, where we do our daily blog posts. And we leave those blog posts up freely accessible for anybody, so you don't have to be a paying patron for about a week. So anytime you go there, there's a week's worth of content, a week's worth of our posts that you can read for free. Doesn't cost a penny. If you'd like access to the rest of the content and some higher level content we offer on that page, then it's $4.99 a month or 17 cents. But you don't have to pay anything. If you were going to the site every day, you'd see just about everything that we offer there without ever having to pay us anything. We do find most people, once they start reading the podcast, decide to become a patron. So we have about 400 patrons on that page currently, and we just launched it earlier this year. The other thing we do free that a lot of people enjoy is we do a weekly Law of Self-Defense show. It's about a 30, 40-minute show. Folks can think of it as a podcast, I guess, but we do it over a webinar platform where it's visual, and we do it live. So people can register. It doesn't cost a penny. Register to get the webinar credentials, log into the webinar. They can see me giving my show live, and there's interaction, so they can ask questions during the show if anything's unclear. And then we also make a recording of each weekly show freely available on the internet for our live show is Wednesday afternoons. We make the recording freely available until Thursday night. So if people can't make the live show, which is Wednesdays, 2 p.m. Eastern Time, they can instead watch the recordings anytime until the following evening. After the following evening, we do lock the videos down for our patrons. So the folks who pay us $4.99 a month have access to the last 3 months' worth of shows. So that's typically 12 shows. And if people are interested in watching the show live or watching the free recording of the most recent show, they can just point their browser to lawofselfdefense.com/show. Again, it doesn't cost anything, but they do need to register so they can get the webinar access credentials. So usually what I urge people to do is even before, maybe even before buying the book, although the book is relatively inexpensive, go read our free content. Go to our Patreon page at lawofselfdefense.com/Patreon. Watch one of our shows at lawofselfdefense.com/show. Doesn't cost a penny. And if they like what they hear, well, then they can make an informed decision about whether to get a book or become a patron or order one of our DVDs.
Excellent. Well, Andrew, I thank you so much for being on the show. Any parting words for our listeners?
Yes, don't get into fights you don't need to get into. It's expensive and dangerous.
Excellent. Thank you. I thank you for being on the show. I look forward to talking to you again soon.
Sounds great.
Thanks again for tuning in to episode 84 of the Out of Order Gun Rights podcast. Show notes page for today's episode is outoforderjameskalita.com/84. Thanks for tuning in. We'll see you next time.